Peter is a pioneer in the field of elder law. So many attorneys like myself learned what we do from Peter, and he is one of the founders of the National Academy of Elder Law Attorneys. He has worked in this field in a variety of capacities. He still teaches at New York Law School. He teaches elder law and runs the Guardianship clinic there. And Peter, in 2019, was awarded by the New York State Bar Association the Attorney Professionalism Award, which is given to one attorney, not just elder law attorney, one attorney in the state of New York. And that was a tremendous honor, Peter, and congratulations on that. And it's been my pleasure to have him not only as my colleague, but as my friend. And with that, Peter Strauss.
Thank you, Lou. It's an honor to be here today. I'm absolutely stunned by some of the information that I thought I knew but didn't, that Valerie and Al have presented to us, and we'll try to build on this today. We're going to have a little over an hour, and we have a lot of information. But I have to say, what Al was talking about reminded me of a thought I had several years ago, that the problem really was the Medicare discrimination against seniors and younger people with disabilities. I used to make what I thought was a joke, but some people took it maybe as more than that. If I was president of the United States, I would switch Medicare and I would say, gee, the real problem is home and community-based services. So from now on, I'm going to get Congress to pass a bill that says Medicare is only going to cover home care and you're on your own for your hospital costs and your doctor's costs. Well, people heard me say that and decided I ought to be institutionalized. But when you come to think of it, that's what we have now. And what Al pointed out was there's some signs, not just in reforming Medicare to broaden the community-based services, but some of the other programs that he mentioned. And there is some hope. So maybe that comet will slow down and not pass the Earth and allow us to proceed. So with that said, I want to introduce the panel for today, and their smiling faces will come on as I introduce them. Frank Hemming is our senior attorney associate at the firm, who knows a lot about what Valerie talked about today. We're all waiting for more answers, but Frank's on top of this, as is Lou and some of our other lawyers. Nadia Arginteanu is the Director of Legal Affairs at NYSARC Trust Services. She's going to talk a little bit about some pooled trust issues today. And of course, we'll be commenting on everyone else's presentations. Nora Baratto is Director of Client Services of EverHome Care Advisors, had years of experience in this field, and certainly has a great deal to tell us today. Suzanne Hallucci is a certified social worker. She's an expert in analyzing the needs of seniors and is our hands-on person on handling fair hearings and knows the process. And our friend Frank Melia, Vice President of Quontic Bank, a little but important bank that many of you may not know about. And of all the bankers in the United States, he has been the one that has provided pathways to new services using trusts when most banks won't touch trusts, certainly irrevocable trusts. Frank's going to tell us a little bit about the role that his bank can play in helping us make some of our goals and practices work in planning for Medicaid eligibility. Let's take a look at the case study to which we will apply what we heard from the first two speakers and the speakers in this panel will address. We're going to talk about Betty Carter, our case study subject, how we're going to evaluate her needs, then talk about how we make her eligible from a financial point of view for Medicaid. We'll also talk about designing the care plan and is she medically eligible for Medicaid? So we've got those two different aspects of a Medicaid application, the design of the care plan, and then finally, all packed into an hour and a few minutes, how the new Medicaid rules will affect what we've done over the past few years and the techniques that we've developed and how we're going to proceed. So let's take a look at Betty for a minute. She's been in the hospital. She wants to live in her own home for the rest of her life. She's 83. She's a widow. She has a cousin who lives next door, two children who live nearby, but they're not really, as is typical in many family situations, able to provide the kind of care that she needs. And this is just a graphic of these three people who are part of the team, but are not going to solve the problem. Financially, well, her health, she had a recent hospitalization. She was offered some short-term rehabilitation, which she declined because she was frightened about the things she's seen in the media about serious issues in nursing homes and rehab facilities, understandably. So she declined that rehab. She's going home. The NA made a referral, and you'll see here that she needed someone around continuously for her safety and supervision, and that may come up again in our discussions. So these are her medical information. She's got some issues: COPD, congestive heart failure. She's got some short-term memory. We don't know at what level she might be on the global deterioration scale, but there are clearly issues here. She has a will, she has a power of attorney, and yes, it has a statutory gift rider. As you all know, as of June 13th, we're going to have a new power of attorney statute, and the gift rider needs to be incorporated, those provisions, into the body of the new power of attorney. And she has a healthcare proxy naming Mary. So that's the overall view. These are her financials. I'm not going to spend time on it, but essentially the issue here is going to be her high income and the fact that she's got non-exempt resources of $350,000. So we're going to talk about how we make her Medicaid eligible, both before January 1st of 2022. We're going to assume that that's going to be the date these new rules are going to be implemented. We think that's going to happen. Of course, it could be postponed again, but it looks right now, and we'll assume whatever the date's going to be, we have to talk about how we function under the new rules. So that's the issue: a high income and some $350,000 worth of non-exempt assets. So what do we do first? What's the first thing? This team, the lawyer, social worker, financial planner, sometimes the accountant, we are a team. And I think you will see from what you've already heard and these new presentations that we don't function independently. We can't do it all. We need each other. So Suzanne, what would you say is the first step? Because I put it here in the outline. What do we need to do first?
So it's interesting. Oftentimes, having worked in law firms and consulting with attorneys, the call usually is prompted by a care need. And in this case, Betty was discharged from a hospital. The discharge recommendation said that she needs a referral to a visiting nurse service, and that someone should be with her 24/7 due to her needs for safety and supervision, but also she needed assistance with toileting, transferring, ambulation. So there's some personal care needs. But when the family is looking towards what do we do next, there's the medical concerns and then there's the financial concerns. So if I was working with Frank, he would bring me into the room and I would sit down with Betty and the family and Frank, and we would start to do what's called a brief functional assessment to get a sense of where this case is going. Can Betty safely live at home? Most people, I've sat down with hundreds of people, and in very rare occasions, are there red flags that a person cannot safely live at home? I would say the red flags that often come up are, is a person a danger to themselves or others? That would prevent someone from safely living at home. And oftentimes, another issue that comes up where if someone needs a two-person transfer and can't utilize some form of technology to transfer, that could be an issue. But the good news for Betty in coming to the firm and sitting down is all indications point towards Betty can safely live at home. Unfortunately, she wasn't given with enough resources to do so. So the family has some financial situations they have to work out with Frank. But I would say, yes, being at home is a go, and let's get to the next step, which would be sitting down with Frank and going over the financials and getting that process started. And then I would most likely circle back for the medical eligibility portion after financial approval was achieved.
Excellent. Now, I just want the audience to know, we're going to assume for today that we have concluded as a result of Suzanne's input and the meeting with Frank or one of the other attorneys in the firm that we're going to move forward on a Medicaid application. But it may be in some limited cases that for tax reasons, or there's sufficient funds in the family, or the unavailability of care in the community, our conclusion may be that we should look at alternatives, maybe drawing down money from life insurance with accelerated benefits. There may be long-term care insurance that lasts for a lifetime. So we don't disregard looking at those other options before we get to Medicaid, which I've always called the payer of last resort. But we're there in this case, and we're going to apply what we heard from Valerie this morning, who will be on our next panel again on appeals. And we go to Frank and we say, okay, we got to implement the plan. What's the plan? What do we do?
All right, thank you, Peter. It's good to be here. I think on below my window, it says that I'm still Lou, so I'm not Lou. I could never be Lou. I just took Lou's chair. So I'm Frank, one of the Franks on this panel, Frank Hemming, because we'll hear from Banker Frank in a little bit. So I'm going to try to make this as simple as I can, because I throw numbers at people. Okay, I actually am on my screen. That's good. Thank you, Bruce. So whenever we look at a case, we have to look at, can we do what we need to do? We take a look at what assets, what income Betty has, as well as what documents she already has in place. So in our scenario, she has that power of attorney. That's important. Without it, we couldn't do a lot of what we need to do. She has that healthcare proxy, so we can make sure that her medical decisions can be made for her if something happens during the process. So just kind of probably recapping a little bit of what Valerie went over, we have to look at what she has for income. In our example, she has $3,500 a month of income. As you can see on your screen, her allowance, since she's a single individual, is $904 a month. She's a bit over that. So what we would essentially recommend when we're done with the Medicaid eligibility is creating a pooled trust. Nadia is going to talk about that when I'm done. We also have to look at her assets. Again, as a single individual, she can have $15,900 of assets or less. She has clearly more than that. In our example, she has $350,000, mainly consisting of that big brokerage account and some other financial assets. So we have to do something with those. So what do we do? Give me 1 second so I can advance the slide here. There we go. Okay, so we have to look at what counts, right? Some things don't count, some things do. When we apply for Medicaid, she can have her allowance of assets, $15,900 or less. She can also prepay for her burial. If she hasn't done that, we want her to do that. We want to make sure that when she passes away, whenever that is, that those expenses are taken care of. The other big one that we have in our example is she does have an IRA. She does not have to spend that down because it is already in periodic payment status based upon her age. So we don't have to do anything with the IRA other than throw it into the income calculation because she is taking required minimum distributions from it. If she had a car, it would be exempt regardless of its value. So she could have the Ferrari sitting in the driveway. I don't think she would in this case, but hypothetically she could. It wouldn't cause an issue for Medicaid planning. So
Frank, don't her farm implements also constitute exempt assets?
If she had a business, a farm that was operating as an active business, then yes. Can't say we've never had clients with scenarios like that, but I don't think Betty would be the one in that case or in that scenario here. But good point, Peter. So then we have to look at other things, right? She has her house. Now, in our scenario, it's already in a Medicaid trust. Betty wanted to get out in front of this a little bit and do some trust planning back in 2019. So like many of our clients, if you get out in front of this, you put some of your assets in trust, but not all of them. So in our scenario, Betty wanted to protect the house. It's already in trust. The other assets that we mentioned on the earlier slide are not in trust. Just to kind of just bring this full circle, her house to be eligible for Medicaid would not have to be in a trust to be protected for eligibility purposes, because if we move Betty back to it, it would be exempt because she lives in it. However, that's only kind of half the problem. Whenever we're planning for Medicaid purposes for a client of ours, we want to make sure that
When they pass away, whenever that is, we don't have a probate issue, because anything that goes through your probate estate, meaning something was in your name alone, no beneficiary, no co-owner, if you've been on Medicaid, Medicaid can reclaim against your estate. So while the house wouldn't present a problem if it was sitting in her individual name for eligibility purposes, we wouldn't want it to be in her name upon her death, because we wouldn't want Medicaid to reclaim against it. We want that to go to her beneficiaries, whether that's the children, her cousin, some combo thereof. So just wanted to make sure that I brought that up. So the current plan under the current rules. So based on what we know today, up until the end of the year, as long as everything we've heard is correct about when the new rules will take effect, all we have to do is do some additional funding to her Medicaid Asset Protection Trust that she already set up back in 2019. This plan, I'm sure Valerie went through this, remains possible because of the COVID emergency. They have not been able to implement these new restrictive rules because of the COVID emergency. However, I did want to mention here that if she didn't already have that trust, we would create one for her and throw in the assets that make her ineligible. So let's go back a little bit. If I can arrow all the way back to just the breakdown of her finances, what are we talking about moving? We have to move that brokerage account, that $300,000 account. That checking account is an available asset. The savings is an available asset. So that's 350,000 of the non-exempt assets. We have to get her down below 15,900. And again, the house is already in the trust. So let's go back forward. So this trust that she already has, let's talk a little bit about it. It's a type of irrevocable trust. We love it because it's the main tool we have in our toolbox as estate planners to protect assets for people that want to qualify for Medicaid. You can name a trustee or trustees to manage it for you that you always have control over. You can always hire and fire your trustees for any reason. So it's likely Betty appointed her children. If something happened to one or both of them, she can change that trustee to be somebody else or just one of them. You also can name beneficiaries of your trust, which essentially says, where does your stuff go when you pass away? The way that we draft our trust, you can change your beneficiaries if something changes between when you make the trust and when you pass away. So it does have a lot of baked-in flexibility, being able to change your trustee and your beneficiary. We want to.
So Frank, let me ask you on that particular point, because I think this is important for people who don't do a lot of this work. The state is always looking for reasons to count the assets in that trust as available for eligibility purposes. How are we able to give that kind of control to the trustees or to the creator of the trust to make those changes?
So essentially, with the change of the trustee, right, as you kind of alluded to just in your question, what the state is really looking for is your availability of being able to touch the assets within the trust and your ability to actually use them for your benefit. This trust all over it says it cannot directly benefit the grantor, the maker of the trust, so Betty in our example. Changing your trustee does not allow you any ability to touch things within the trust that you didn't already have. So that's why there's the ability to change the trustee without any Medicaid consequence. Changing the beneficiaries does get a little more interesting, we'll put it that way. We typically use something called the power of appointment, which essentially allows the grantor to make a change of the beneficiaries while they're alive, but it does not give them any other access to anything during their lifetime of being able to pull things out for themselves or use it for themselves where they're alive. It only directs where things go upon their death. So while it is a related concept, it does not allow them to go into the trust and do things with it that they wouldn't normally be able to do. So I kind of hope that that answers your question, Peter. Did I do a good job with that?
Thank you, Frank.
All right. So what do we put in, right? We can put in the home if it wasn't already there. We can put in bank accounts. We can put in that brokerage account. If she had any of the other listed things, annuities, life insurance, we could put those things in there. Okay, so we also have some other features. We kind of already talked about this. I'm going to keep going. Some advantage of the trust, probate avoidance, right? Keeps you out of probate, keeps make sure that you don't have that estate recovery issue. It also allows you to do additional planning for your beneficiaries. So at our firm, we do a lot of trusts that create trusts for the beneficiaries. We have done a lot of educational programs here at the firm that talk about this concept. Please go on our website, look at all those good videos that are there if you have any questions about that. But this trust does not only set up Betty for success, it also can do further things down the line for the other family members. Under the current rules, if we do all of these good things, we're able to still qualify for community Medicaid basically within a month or two, because again, COVID has extended the period of time that we have to use planning to take care of all these existing rules. Now, the new rules, let's talk about those. Valerie, I know talked about a lot of this in detail, so I'm not going to talk about it in detail, which is kind of rehashing them here. The new rules, we believe, will take effect January 1st, 2022. What is that essentially going to mean? It's going to mean that there's going to be a new look back period for home care purposes that did not previously exist. So starting January 1st of 2022, there will be a 15-month look back from January all the way back to October of 2020, where the county will be able to look at what you've done with your finances in that 15-month period of time. If you move things away from yourself to a trust, to a family, or to a child, to a grandchild, they can penalize you for Medicaid benefits. So once we get to the new world in 2022, we can't just throw things in Betty's asset protection trust without planning for that. It's going to create new issues. It's going to create a period of ineligibility. This is exactly the type of system and planning that we see now for nursing home purposes. So essentially, we have to create a nursing home planning technique and use it for a home care case once we're into the new rules. So let's talk about that. What do? We do something called a promissory note and gift plan, or a rule of halves transfer. It's the same, it's two different terms, same concept. Essentially what we're able to do is we're able to take all of the available assets that are creating the Medicaid eligibility problem. So again, we're going to fast forward, we're going to pretend like Betty's now in 2022. She still has that $350,000 of assets that are creating a Medicaid eligibility problem. We then do some very complex calculations, and we essentially can come up with a formula where we can save roughly half of the assets from going to Medicaid. We are able to also create a stream of income for her that will help make sure that she has the funds available that are needed to be used to fund her care during this period of ineligibility. So I know that's complex, I know that's confusing, so I'm going to do my best to break that down a little bit better. One quick reminder, whenever we're doing calculations with promissory notes or nursing home planning or the new rules for home care, we have to know what our regional rates are. Because when we're doing these complex calculations, we have to know what numbers we're using. So in 2021, we have those numbers. They're now on your screen. Obviously, these would be different in 2022, but since we're not there yet, we don't have those numbers, so we have to use what we have. So the example will use the 2021 numbers, because that's the best we can do. So let's look at Betty, because that's what we're here. We're here to talk about her. Currently, she has $3,500 a month of income, $350,000 of non-exempt assets. She requires 24/7 care, right? That's what Suzanne wanted to vet right at the beginning before she came to meet with the firm. So we have to put a number on her cost of care. So what I did was I took $25 an hour for care times 24 hours a day. That's $600 a day, roughly $18,000 a month. So those are their numbers that we're going to throw into our calculation. We always like to spend her down a little bit, right? If we're going to lose some of her money, we might as well use as much of it as we can to benefit her before we start hacking things up. So her family did some spending. They bought that prepaid funeral arrangement. They bought her a TV. They bought her some clothes. They had to pay for her legal fees. So we were able to spend down an additional $20,000. So in my example, now we're dealing with $330,000 of non-exempt assets. We're going to keep some with her, right? Because she can have $15,900 or less. And then we throw the numbers into the calculation. What we came up with was that Betty would be able to gift $146,083.86 to her Medicaid Asset Protection Trust that, again, she already has set up. And then she would loan essentially the second half of that money, $170,416.14 would be loaned to her family. So what did we do? We just moved a lot of money around. So let's kind of break that down a little bit. We look at what her cost of care would be. Again, that's $18,000 because she's privately paying for 24-hour care at $25 an hour. She gets an income stream. We have to take that into account. So we have to look at how much she needs to privately pay that she doesn't already bring in on her own. So she's shortfalling essentially $14,500 a month. We then look at her assets. Again, we started with 350, we spent her down a little bit, and we're gonna keep $13,500 with her. She doesn't have to have $0, she has to have less than 15,900. So our at-risk capital of what we're working with is $316,500. We make that gift of the $146,000. And when we do that, we create a penalty period on purpose. So we take the amount of the gift, we divide that by our penalty number. So since our office is in Albany, we use the Albany current number because that's the best number we have. And by doing that, we create a 12.5-month penalty. This is exactly the plan that we do for a nursing home. We're just, now Betty's going to be living at home. So essentially, what did we do? We took some money, we gifted it away to the family. We put it in that trust and said, this is your inheritance. This is what we're saving by doing this. And by doing that, by saving some money, we're creating a 12.5-month penalty on purpose. So now we have the second half of the money. We have to do something with it. We have to get it away from Betty. She can only have 15,900 or less. So we loan it to the kids. This has been a tried and true technique that has been litigated through the courts, that if you structure the loan properly, it's not an asset any longer of Betty's. So she loans $170,000 to her kids for 12 months. And if you kind of think through the mechanics of this, essentially what we did was we were able to save roughly half the funds and then create a loan that's going to pay $14,300 a month to Betty for 12 months, which is the amount of the time that she would be ineligible for Medicaid because of the penalty. So by doing all of this, we've now created Medicaid eligibility for her 12 months later. So we always have to look at timing when we talk about Medicaid. So since we're in the new rules, we were doing all this stuff in January. So we do all these transfers in January. The first avenue to apply would be February 1st of 2022, the new into the new world. That penalty runs for 12.5 months, and she becomes Medicaid eligible February 1st of 2023. So kind of to recap, what did we essentially do for Betty?
Frank, can I just interrupt with a question? Because I want to make sure I understand this. Do you
Sure.
have to apply immediately in that February timeframe and get a denial in order to start the penalty period?
Yes. I just wanted to clarify one thing you said in your statement. That's why I paused for just a second. You wouldn't necessarily, just to be clear, the way that I would phrase kind of what you just asked, Peter, we wouldn't necessarily receive a denial. We would receive an approval, but with a penalty period. So we would get approval, but with a 12.5-month penalty. But yes, we'd want that we'd want to immediately apply to begin the penalty running. That is exactly true and exactly what we would want to do. Correct about that. So by doing this whole plan, we now have the trust that was already in the house. We put an additional $146,000 in the trust. We left some money with Betty. We prepaid down we prepaid for that burial, and we didn't have to touch her IRA because it was safe as it was with her because of her age. So when we started with all of that money at risk, at the end of the day, we were able to finance her care privately for that 12-month period, and we were still able to shelter just shy of $600,000 for her care going forward, because we want, one, to leave a legacy for her family, and it's also available resources that if she needs additional things, right? She has home repairs, she has other expenses, that money's still there that can be accessed by her family to care for Betty for the remainder of her life. Now, I know that was a lot. I know there was a lot of numbers. I tried to make that as simple as I could. It's a very complicated process. We do it all the time. We try to make sure that when we're doing educational programs like this, that we're communicating the concepts. So everything that I just talked about creates financial eligibility from an asset perspective for Betty. But because she has that large amount of income, that $3,500, we also have to plan for her income eligibility as well. We use pool trusts for that. Lucky for us, we have Nadia on the panel who works for the NYSARC, who's a very large charity and a very large pool trust that we very much enjoy working with. So I'm going to pass this off to Nadia so that way she can talk about the pool trust and how it works.
Frank, that was really clear. I mean, I think that was a terrific presentation. And I guess the message is, and I assume you'll agree, there's still time. This has to be done. I mean, you showed us what you'd saved even when we were into 2022, but we could save more if the planning and the application is filed before December 31st of this year.
Of course.
That's something that's the clear message from your presentation.
The biggest thing here is any person that can apply should apply under the existing rules, right? Sometimes we can't apply for everyone because they don't have that care need now. If you don't have the care need, you can't apply. So if you don't get the care need until next year, we're kind of forced to the new rules. But if it's somebody who's kind of on the fence or develops a care need between now and the end of the year, they should be applying now. That is the best thing they can do.
So, Nadia, Frank's clearly stated the process to protect the assets. What about income? What's our income problem and what do we do about it?
What about income? Thank you, Frank. As I said, my name is Nadia Arginteanu. I'm the Director of Legal Affairs at the ARC New York. And part of what we do at the ARC New York is operate NYSARC Trust Services, which is a special needs trust program. And one of the programs we run is designed to help in situations just like this, where you have people like Betty who need a trust to protect their income on a monthly basis. So what a special needs trust is, if we could just go to the next slide, please. Thank you. So unlike the trust that Frank was just talking about, a pooled supplemental needs trust or special needs trust is a particular type of trust where instead of having a family member or someone that you choose to serve as trustee, you have a not-for-profit organization like NYSARC serve as the trustee. And then this is a trust that holds assets for someone with a disability that helps them preserve their eligibility for means-tested government benefits like Medicaid. And your first question here might be, well, is Betty disabled? Does she even qualify for this program? And even though you might not traditionally think of Betty as disabled, she actually would qualify for this most likely under the Social Security Administration definition of disability, which is someone who is unable to have substantial gainful employment for a period of a year or more. And due to her COPD, her congestive heart failure, and her memory issues, she will meet this definition and therefore be able to use the pooled trust. And under federal and New York state law, people with disabilities are allowed to use a pooled trust to shelter excess income or resources to maintain their eligibility for government benefits like Medicaid or SSI. So in this case, Betty's going to use the trust to shelter her excess income, but there are other situations where someone might have resources where they wouldn't be able to use the type of trust that Frank was just talking about, but a pooled trust might be able to be a good resource for them to shelter those excess funds. And then once the funds are in the pooled trust, they can be used to purchase things to enhance the individual's quality of life in ways that the person's government benefits do not cover and will not be able to provide for. So there are a lot of different benefits of a pooled trust. First and foremost, obviously, it's going to help someone qualify for Community Medicaid to get those healthcare benefits and the long-term care services that they need without a complete loss of resources. And that helps them maintain their financial independence. And that's going to help them maintain that comfort and independence in the community. For a lot of people, without being able to access this type of program, they would be forced into a nursing home or another institutional setting really before it would be necessarily appropriate for them. But if they wouldn't be able to qualify for long community-based home care services, they wouldn't have another opportunity. They would have to go into a nursing home to get the care that they need. A benefit of the pooled trust is that when they use the pooled trust, they're going to have those excess funds available to them to pay for their living expenses in the community, as well as to enhance their quality of life by paying for things above and beyond what government benefits might pay for. Using a pooled trust can help someone transition home following a short-term rehab stint. And another benefit of this is being able to access those home and community-based services can be a really helpful relief for family caregivers. Like in Betty's situation, when we first started talking about it, she had family members there who were staying with her overnight, and that wasn't going to be something that was going to be able for the family to do long-term. So I won't spend too long on the numbers because Frank already did a lot of numbers, but just to quickly go over it again, these are some of the income numbers that we're looking at when we're talking about Medicaid eligibility in New York State. And in New York State, income that is received by an individual, if it's placed into a pooled trust in the same month that it is received, is going to be disregarded for Medicaid eligibility purposes. So for Betty, we're looking at that individual income limit. So for Betty, because of that $3,500 total monthly income, after the amount of money that Medicaid lets her keep each month, which is money that she's going to be able to keep in her own account, in her own pocket to spend at her own discretion, she'll have to put about $2,500 into her trust, minus an administrative fee that NYSARC or any pooled trust program will charge. And then she'll have about $2,300 left to spend each month out of her pooled trust. And the exact amount of what someone's excess monthly income is going to be determined by Medicaid. In terms of how a special needs trust is administered, there's a few main rules that apply to all pooled trust administrators, not just NYSARC Trust Services. The real primary rule is that disbursements from the trust have to be for the benefit of the trust beneficiary. And what this means is that money in Betty's trust has to be used for Betty. It can't be used to buy things for other people. It has to be used to pay for things for Betty's primary benefit. In order to substantiate that that's how the funds are being used, most pooled trust administrators request certain forms of supporting documentation, which we keep on record in case Medicaid or another government entity wants to confirm how the funds were used. And that's how we can confirm that the funds were used appropriately and for Betty's primary benefit. Disbursements can only be paid to third parties. And this is really because if we gave the money back to Betty, we'd basically be undoing this protection that we just spent all this time creating. So we need to pay third parties, and there's a variety of ways that we can do this. And one of the other rules that we like to keep in mind and always remind people is that the federal regulations and the Social Security policies that govern pooled trusts such as this say that when someone passes away, their trust account has to close and we can't make any additional disbursements. So we always like to encourage families who are helping someone use a trust to send in disbursement requests to the trust administrator as soon as they're received, just to ensure we don't want people to be, on top of the loss of a loved one, have also a pile of unpaid bills. We want as much of the money in the trust to be used for the benefit of the trust beneficiary as possible.
Nadia, before you move on the issue of the sole benefit for Betty, suppose she had a son on the spectrum, not getting disability benefits perhaps, but can't work. He lives with her. Is he getting a benefit from the use of the money to care for her house that would violate this rule?
So that's a really good question. So the way that this is looked at by the courts is that the purpose of that rule is not to have someone who has a pooled trust or a special needs trust like live in isolation completely alone. So it's not saying that if the trust pays for someone's home or pays for their television or something like that, that no one else can live in their home and that no one else can watch their TV and that they're supposed to be completely isolated. That actually completely goes against the constitutional mandates that we have about having people with disabilities in the most integrated setting possible. But what it does say is that even if Betty's disabled son lives with her, we can't buy things specifically for her son. But if he happens to live with her and we're paying for her home and the home is in her name and her bills are in her name, if he has an incidental benefit to that, that would be okay. But we can't buy things specifically for her. And sometimes that's difficult when we have people who want to buy gifts for their grandchildren and things like that. But we also like to point out that in addition to all those funds that Frank was able to save for Betty using that estate planning, she also gets to keep $900 a month of her income that she's able to use however she wants. So we always encourage people to do is use the money that's in the pooled trust to pay your bills, pay your electric, pay your mortgage, and then use that money you get to keep to pay for things that are more discretionary that might not be able to pay out of the trust.
Very clear. Thank you.
You're welcome. So these are just some examples of how disbursement requests can work out of a pooled trust. Like I said, we'll have to make payments to a third party. We can't make distributions to the individual. Otherwise, we're undoing that protection we've created. So these are just a few different ways that that can happen. One of the most common ways is that a trust administrator is just going to pay a third party directly. Whether that's a bill, it's a mortgage, they're paying an insurance premium. A family can just submit the bill directly to the trust, and the trust is going to pay that bill. Another way this happens is that we are going to reimburse an individual. So maybe Betty's neighbor, Betty's friend, Betty's children are going to buy her groceries. They're going to buy her clothing. That individual can submit their receipt and we can reimburse the individual. That's another thing that we do quite frequently. Something that we often suggest as a really easy way of facilitating that type of transaction is encouraging people to use a credit card. Because if you use your credit card to buy things for other people, we can actually pay the credit card company directly. And that way, let's say Betty's children are buying her groceries. Instead of Betty's children being out of pocket for those purchases, they can use their credit card and we can pay the credit card company directly. Another way that trust disbursements often happen is getting a quote or invoice for a service or purchase. This often happens for bigger purchases like home repairs or assistive technologies. Sometimes when we have someone who's coming back to the home from a hospital stay or a rehab stay, there are certain changes that need to be made to the home, like adaptations to the bathroom or kitchen to make the home safe and comfortable for them to live. And for something like that, they might get an invoice or a quote for a larger project. And then that quote or invoice will be submitted to the trust. And then the trust could pay the contractor or company directly. And these are just a few different ways. So on this slide, you're going to see a non-exhaustive list of all the different things that someone's pooled trust can pay for. These are the things that trust typically pays for, but what I always say is that there's more things that a trust can pay for than the trust can't pay for. It really is anything that is for the primary benefit of that trust beneficiary. We do at NYSARC Trust Services have some internal policies that we don't pay for alcohol, tobacco, firearms, bail, restitution, or illegal activity. That's just based on our own interpretation of the public policy behind the allowance of these trusts, is that that's not what the state was contemplating when they allowed for this program. But really, there's so many things that the trust can pay for. And we always say that if there's something that the trust can't pay for, there's usually something that the trust can pay for that is being paid for out of pocket or by a family member or something else that the trust can start paying for to free up some more funds to pay for the expense that the trust couldn't pay for. So the impact of the 2022 rules. Unfortunately for the pooled trust industry, we have a lot of lack of clarity here. And there's been a lot of advocacy happening from pooled trusts such as NYSARC Trust Services, as well as the Elder Law Bar and other organizations. And while we are confident that the pooled trusts are still going to be allowed to be used, we're not really sure how that's going to look like. And one of the things that we think might happen is that people are going to have to spend their entire trust deposit in a given month. And this is going to be really challenging because for a lot of people, they don't have $2,400 of monthly expenses. Betty might not have $2,400 of monthly expenses. And what many people do is they have some monthly expenses, but then they also let a small balance build up in their trust over time to pay for larger annual expenses like an insurance premium or their property taxes. So this is something that the trust industry is advocating about with the Department of Health, and we're hoping that this is something that's going to be changed prior to the implementation of the new rules, because frankly, from a time and manpower standpoint, it would be a lot of work for both the pooled trust administrators and the Department of Health to manage and track all this information on a monthly basis. But this is something that we're going to have to keep in mind, and we're going to have to kind of think of maybe some new and unique ways to help people spend their money on a monthly basis. We don't want people to be spending money frivolously, but we also don't want people to lose their Medicaid eligibility or to have difficulty, paying their property taxes and things like that. So this is something that we are tracking and paying attention to. I know Frank Melia from Quontic Bank is going to join us next and have some suggestions about how maybe mortgage options can help particularly with that property tax issue. And thank you. I'll be here for the Q&A.
Thank you, Nadia. That was clear and within the time frame that we have. I just want to say to our audience that this issue of having this accumulation, and which might be counted as a transfer and require a spend down, could really jeopardize the whole ability to keep people in the community, because if we can't shelter their excess income, they may not be able to maintain their home. So if you belong to organizations and bar association committees, please raise this particular issue with those organizations and join the lobbying effort to change this. Which leads me to Frank Melia, with whom we've worked for many years. And as I said earlier, he has created new thinking in the banking industry. It's a small but fabulous bank to work with. And I give it to Frank for a few minutes to talk about how he can help us on the problems we've been discussing.
Thank you, Peter. I just wanted to wish everyone a great afternoon, and I hope everyone's healthy. Quontic Bank is based in New York City, and we're a federally chartered bank. And I've been working with elder law attorneys and people like on today's panel and people in our industry for the past 10 years, specifically to keep our senior communities safe in their homes. Why Quontic Bank entered this industry or entered this segment or marketplace is because it's underserved. We have a CDFI designation at our bank, which is a community development financial institution, which basically means that we provide services to the underserved, the underbanked, and the lower income communities around the country. As Nadia stated earlier, there are going to be some changes, or there are some proposed changes. So what I'm just going to discuss today very quickly is just some options that may come into play if these provisions do get passed, and just cover a couple of different basic options that our bank provides when there's a Medicaid Asset Protection Trust. What Betty is facing is obviously some proposed new rules that Nadia alluded to pertaining to a monthly spend down. So if we are faced with trying to help the communities and they have to spend down their allotment of funds every 30 days or every quarter or every 6 months, depending upon the proposed changes, one option, which the panel discussed, is to possibly finance the property. If Betty were to take a mortgage, let's say out on the property, we would include her escrows. We would include her monthly real estate taxes. It's mandated in our guidelines at our bank for any trust borrowing options. So we would escrow for her real estate taxes, and we would escrow for her homeowner's insurance. So those were two of, and as Nadia mentioned earlier, those are two of the larger expenses that all homeowners face, especially someone that's homebound, that's getting community-based Medicaid or has private pay care. So structuring the mortgage the way we do inside of a Medicaid Asset Protection Trust, in Betty's scenario, maybe she doesn't have any existing liens on the property, so we would be able to extract some equity, put those proceeds into the Medicaid Asset Protection Trust, which would be controlled by the trustees for the benefit of Betty. So it would free up some equity in the property, because as Frank also alluded to earlier, with the loan scenario where the trust can pay back the loan for 12 months until Betty became Medicaid eligible, what happens after that period? From our experience and, discussing it with the panel, sometimes people do have to go to the private pay option if Medicaid won't cover certain expenses or certain hours. So that would free up some capital from the property inside the trust. And also, as I stated, allow the trust to make that payment on a monthly basis for the mortgage, which we won't have to address how to make that insurance payment, 12 months down the road, or make a tax payment every 6 months.
So you're really leveling the obligation to avoid the buildup that might cause a payback problem or an ineligibility problem.
Absolutely, Peter. As we discussed earlier, with Lou and yourself, it's a strategy that, if these laws are passed, and if, depending upon when the payments have to be made, when the buy down, when the pay down has to be done from the trust, this will alleviate the tax payment and the insurance payment, which, as a homeowner myself, those are some of the larger payments that homeowners face.
Well, congratulations, Frank. You've just been appointed as a member of the solution team here with the lawyer, care manager, accountant, and banker.
Go back one more second, Beth, on that slide. We could do up to 75% financing inside an IRREV trust, all IRREV trusts. We predominantly work with the panel and a lot of professionals around the country regarding MAPS, Medicaid Asset Protection Trusts, but up to 75%. Like I said, we escrow. We offer a 5-year ARM. We offer 15-year and 30-year fixed. And we do also offer lines of credit, but that's through the home equity conversion mortgage, which I'll discuss on the next slide. This slide was added because knowing the panel and speaking and working on many cases with the law firms that we work with, some families do look at the option of the reverse mortgage, which is the home equity conversion mortgage. That's the HECM acronym on your slide right now. And just look at the definition, a home equity conversion mortgage. It converts equity in the property into proceeds that can be used today. Okay, in Betty's scenario, she would be approved. Okay, the income requirements are much less to qualify for a home equity conversion mortgage than a typical 30-year mortgage. Based on a 350 value, there'd be about 210 available inside of her line of credit. So that 210 now becomes available to her through her trustee and the trust account to pay for some of these expenses that may not be covered through the planning that Frank's implemented or Nadia working with the pooled income trusts. The draws are available 24/7. All draw proceeds from our bank go into the trust checking account to protect the integrity of the trust. The proceeds are used for long-term care costs. I get 10, 15 calls sometimes a day from attorneys around the country, and it's always filling that void of the long-term care costs. The one key feature that a lot of families like when they understand the program is that the line of credit grows by 5% a year. The unused portion that you have not tapped into yet continues to increase by 5% a year. So it allows the equity in the property or the proceeds to stretch out a little bit longer to keep Betty in her home. We do allow powers of attorney. There are some rules regarding powers of attorney, so we can go over that, one-on-one. And guardianships. We work with a lot of Article 81 guardianships through many of the courts, so we do allow that as well. One last thing regarding our 30-year fixed rate and 15-year fixed rate and adjustable rate mortgage, not the reverse mortgage. We have expanded this program, thankful to all of the attorneys that are using us around the country, to now offer what we call no ratio. Simply put, we're not going to look at income. So in certain scenarios, if the person did not qualify or if Betty did not qualify from an income perspective, from a bank guideline, we could still most likely get these mortgages approved. They might be a lower amount, but it's credit driven and it's equity based driven. So between the no ratio, we can go up to $3 million if there's any downstate in the city, but $3 million should be no problem with most of the families that we work with. And right now our trust loans have rates as low as 4.625%, and the line of credit through the home equity conversion mortgage have rates as low as 2.7%. So with
Frank,
that in mind,
do I understand that you can draw down as needed? You don't have to take a lump sum, correct?
With some trusts, Peter, depending upon the language and how we approve the trust, there may have to be a distribution and a draw at the closing just to show HUD, the regulatory agency for these programs, that we funded the trust. But then what I tell most families is after 90 days, once the trust is set up, I mean, once the account is set up through the reverse mortgage, they could pay back some of that balance so they don't have to accrue interest. So it is a revolving line of credit. But yeah, we do fund the trust with some money. That's just to show HUD that we funded the trust and we didn't send the proceeds directly to the borrower. So we don't violate the trust document.
And while this is not our primary concern, it would reduce the payback at death, which would benefit the ultimate heirs of the trust.
Absolutely. Thank you for your time.
Frank, terrific. This is really unusually creative and it's going to be very useful to us. So,
And Peter, just so you know, for this particular panel session, we have approximately 12 minutes left until we can continue to the next panel session.
okay, so let's let Susan pick up here on some thoughts about how we make this application process work and what some of the concerns are.
Well, I
And
think
maybe
the
leave a little bit
audience,
for Nora as well.
yeah, I think the audience now sees the hurdles, the obstacles, the challenges of getting to financial approval, helping the family understand how to use, protect the assets, protect the income. And now we're dealing with the Medicaid medical eligibility portion, which is another huge obstacle that families must, need to go through to help get Betty the services she needs. As we left her off, she was discharged from the hospital. She had a visiting nurse referral. By this time, the visiting nurse, skilled nursing services have most likely stopped. There may have been an aide coming in from a certified home care agency helping Betty get a bath maybe twice a week. But all the while, care is lingering out there, she's needing more assistance. We established that she needed 24-hour care. So the first step in the Medicaid maze of medical eligibility is having the conflict-free assessment. And what is a conflict-free assessment? What does that even mean? What I often tell families that the conflict-free assessment is just to establish community-based services. So it's pretty much a yes or a no situation. It is done by a nurse from New York State through Maximus. It is the UAS tools used, the nursing assessment that Valerie referred to earlier. And it looks at functional assessment and it establishes someone can safely live in the community and if they qualify for services. In today's world, as Valerie said, you just need one ADL to trigger the benefit. And if you qualify, the nurse will tell you, they'll either tell you at the conclusion of the assessment or call you an hour or two later to tell you that you qualified for services. And now you can move on to the second step of the process, which is reaching out to a managed care provider. You have 75 days to obtain the second nursing assessment. So families will reach out and start to bring in the managed care providers to do the same exact assessment. I call it Groundhog's Day because we're going through another assessment, 2 to 3 hours in length, asking the same questions. But the managed care assessment is then determining the amount of hours. I can tell you I've probably done 500 UAS assessments in the 10 years I've been doing this. In the last couple of years, I can honestly tell you I have only once been able to trigger a 24-hour benefit. You think I'd get really good at this point in time, but most plans are only offering about 5 to 6 hours a day, regardless of how much care someone needs. So oftentimes I'm with the family when this happens, they're shocked. There's not much we can do because an individual does not have any enrollee rights until they're enrolled into a plan. So the recommendation is accept an offer, wait for the first day of enrollment, and we'll talk about the appeal process later on. But this is the reality in 2021, how the assessments work. I'm going to turn it over to Nora to talk about what it's going to look next year. I don't even want to wrap my head around that. So Nora, I gave you that honor, but it's going to be challenging.
Thank you, Suzanne, and you're going to stay with us for the next panel on appeals. So Nora, you've got about 7 minutes, I'm sorry to say.
Well,
Wish you
what
had
I
more.
can say is growing old isn't for the faint-hearted. And boy, if there's ever a need for people in the audience to think seriously as you grow older, you really do need a team of experts. I make the analogy for the medical profession where you have a lot of specialists with your primary care and you have a whole team around you. As you grow old, this is what it's come to. We really do need that supportive team around you because this is very complicated for older adults and for families to understand. And now add all these new rules and it's just going to be overwhelming. So fast forward to 2022, new Medicaid rules. Betty comes to us for financial planning in February 2022, and she's got to qualify for Medicaid. So the new 30-month look back starts January 2022. So as Frank mentioned, making a penalty, that penalty after they do the financial planning and get her assets straightened out is 12.5 months penalty. So as Frank gave in the example, after sheltering some of the funds to pay for her care, she's going to have approximately $14,300 a month to pay for needed care. So Frank and I have to work very closely together to help the family through this complicated maze. So that's the importance of getting to know what an aging life care coordinator does. We're experts at assessing care needs, helping families go through the crisis, because this really is like going through a workman's comp system. You don't know, and they really need that support and guidance because you know what? They're key to keeping people in their own home. So we have to really support them in that endeavor. Next slide. So care management of the present and future. How will Betty's care be different? Well, in the new realm with all of these rules changing, especially what's distressing to me is the independent physician assessment. I have a lot of background in healthcare and it reminds me of the old utilization review physician. It's really important that as an aging life care coordinator that we are advocates to making sure all that medical information is true and correct and in the chart. HIXNY, which is the information exchange, computerized information exchange. Nowadays, doctors can go in and see their medical information if they have consent to HIXNY. So it's really critical that information that's getting in there is important, all of her diagnoses. And one thing that we mentioned is a dementia assessment. We really need to get that assessment and have the family explore that because that term short-term memory and needing 24/7 care, it's very variable according to who you talk to. And that does go into the safety issue. There's a lot of people that make that judgment that they're not safe and they really don't have anything to base it on. So it's important in our role to help get that dementia assessment on the records. In the new assessment tool, the ADLs, we already know that she needs 24/7 supervision. She needs help with bathing and dressing and transferring to the toilet. So my assessment would be when you look at that and then you look at her health condition of CHF and COPD, you know, medication supervision is critical. Diet is critical. You know, a lot of older people, I used to laugh at it when I worked in the hospital. You know, they would come in and they're in CHF, yet nobody's really asked them, tell me what a typical day is when you're eating. And almost all the time we'd say they're using TV dinners and that throws them into congestive heart failure, which throws them back into the hospital. So these are really critical. They have to look at the totality of the situation and all of these factors. So what's my recommendation to this family? Given all the moving variables in that, is to look at and make a referral to the nursing home transition and diversion program. Why? It's not subject to the same rules as these managed care, the Maximus assessment. You can make a referral at any time. And the whole goal of that program is to keep people that want to live at home in their home for as long as possible. So they have regional resource centers that will do an intake. And of course, what's the drawback? The drawback is they have to have their Medicaid in place. And sometimes it takes, 6 months or more. I know Suzanne and I were talking in downstate, it takes a lot longer, doesn't it, Suzanne?
It does. And I just want to add one thing, because I know there's probably a lot of social workers who work in rehab facilities and in hospitals. I think it's important when a discharge recommendation is made, such as the one for Betty with, we recommend 24-hour for safety and supervision. I think it's important to bring in the team of PT, OT therapists and embellish that a little bit more. Valerie spoke before that we got to tie in safety and supervision to activities of daily living in order to help trigger. And when we speak about the appeal process later on, I'm going to share with you how plans take advantage. Managed care plans love that word 24-hour safety and supervision, and they use it to our disadvantage. So I think it's very, very important for, the entire team, including from point of discharge and the hospital social worker, the rehab social worker, to understand how this family is going to move along the care continuum and to make sure we have proper documentation, because we're going to need it in black and white later on to help win more care for Betty. So I think that's like
I just want to point out to our audience how critical it is to engage a care manager with the experience such as Nora and Suzanne have, and there are many others out there, to one, monitor the home care plan over a long period of time, but as important, in the beginning, to assist in structuring the application and the process. Because while lawyers like Frank and to some extent Lou and myself, that's not our expertise. Frank, to a greater extent, has it. But we need to have the care managers with this kind of experience of the system so that when we get to the legal aspects, we've laid the foundation for the appeal, which is where we're going to go now. So I really want to thank Nora and Frank, and Suzanne is going to stay on, Frank is going to stay on, and Valerie is going to join us again for our next 30 minutes or so to talk about appeals. And why do we need an appeal?